This is the In Focus podcast from The Hindu.
Hello and welcome to another edition of the In Focus podcast. I'm your host, G. Sampath. The Union government recently introduced a bill in the Lok Sabha to amend the 1995 Waqf Act. The provisions of the 1995 law govern the administration of waqfs, which are properties endowed for charitable or religious purpose under Islamic law. But opposition parties have accused the government of trying to undermine the religious rights of Muslims through this amendment, which is titled, interestingly enough, I quote, Unified Waqf Management, Empowerment, Efficiency and Development Act 2024. The government, on its part, has claimed that this legislation is aimed at enhancing, quote unquote, the efficiency of the administration and management of the Waqf properties. But following a public outcry, the draft bill has now been referred to a Joint Parliamentary Committee or JPC for further scrutiny. And when the JPC sought written suggestions from the public on the draft bill, it received a staggering 1.2 crore suggestions. And earlier this week, when the JPC gathered for a meeting, the opposition members of the committee walked out, alleging that the panel was not functioning as per the rules and regulations. So, what exactly does this bill seek to do? What are the objections to it? Did the government involve Muslim stakeholders before or while coming up with this draft bill? And what is the way forward? We examine this bill in close detail in this episode of In Focus, and we have with us Fuzail Ahmad Ayubi, who is an advocate on record at the Supreme Court of India. Mr. Ayubi, welcome to In Focus. Thank you so much for joining us.
Thank you very much for inviting me.
So to start with, I was just wondering if you can give us some background. The first Waqf law that was exclusively created for Waqfs was the Musalman Waqf Validating Act of 1913. And since then, there have been several changes to the legal regime governing the administration of Waqfs. There have been a number of acts, amendments. Can you give us a quick historical, overview, a run-up of what exactly a Waqf is? What are the changes to the legal regime governing them that have taken place until this present moment when this bill has come up in the Lok Sabha, which they did it in August, it was introduced in August this year?
Yeah, the first and foremost thing I think is to understand what is Waqf. Waqf means a dedication. It is in a common sense word, if I say that in all religions, there is a provision to give dan, to give endowment, to give in charity. And therefore, this provision also is there in all religions, so is in Islam. Here, the five fundamental tenets of Islam, wherein charity is one of the fundamental tenet. That is 2.5% sort of a tax that everybody has to give. And that is something we can call it a compulsory charity in the form of zakat. Now, here, this is also related to it in some sense that this is not an compulsory, but this is an obligatory charity, wherein I want to please my maker, and for that I want to part certain portion of land and property, and I want to bestow it to God Almighty. So this is sort of a charity in perpetuity. So what I do is that one thing that is there, that I should own it. I own the land, and then I have this feeling to part with this land in favor of God Almighty, and then I relinquish my right and hand it over to God Almighty for all times. Now that is one way. The other thing is that I can give it and dedicate it to my family as well, because dedication towards family and kindred and children is also being recognized in Islam as a good charity. So I can dedicate it to God Almighty to be used for purposes recognized in the Muslim faith as religious, charitable, and pious. And secondly, I can also give it and dedicate to my family.
So giving it to family is like in passing on inheritance, right? How is it? How is it a religious thing?
Yes. So that is not sort of an inheritance in the sense that there the family cannot transfer it further. It cannot sell it. It will remain with the family only. And when the family line is extinguished or it's over, then it will revert to the God Almighty for the religious, charitable, and pious purposes as recognized in the Muslim faith. So this is the very basic concept of waqf, that there is a dedication. I am the dedicator, I am the waqif, I dedicated it to God Almighty. The God Almighty becomes the owner. I appoint a manager to look after it. I can appoint myself, I can appoint anybody who is called a mutawalli, and that he will look after that property. And after him, he can appoint, or the board can appoint, or somebody else can appoint after its death another person who will act as a manager caretaker called mutawalli. Now this property, the benefits of this, I can indicate, okay, this could be for a particular purpose, like for a school or a well or a inn or whatever. So that is on the concept level. Now what our acts do, our acts, this is our religious function, which has a ramification so far as social and economic sphere is concerned. So I do this religious act which has a socio-economic effect, impact, that is being covered by this act is recognized, this function of giving charity, and then this socio-economic aspect also is being recognized and captured in the act. The first exclusive legislation, as you rightly said, regarding the work was 1913, wherein this aspect was being recognized very clearly. Now, what happened? That in fact, this whole requirement of the 1913 Act was for this reason, that in one of the decisions of Privy Council in Abdul Fattah Muhammad case, the Privy Council held that this family dedication was void. It was held to be void, and there was a massive protest on that. So this was for perhaps for the reason, what the reason was that the English justice failed to understand that Islam envisages bestowing property to one's family as elm. So the 1913 Act, therefore, was more toward recognizing Waqf al-Aulad, that is family Waqf. The charitable and religious Waqf, of course, were still recognized as part of the Muslim faith. And then there was this further development in 1923 when the verbal appointment of Mutawalli was recognized. Then subsequently in 1930, there was a retrospective effect which was being given to the 1913 Act. And notably in the 1930s, for the first time, the boards of Waqf were introduced as a supervisory body. And state of Bengal did it in 1934, and UP did it in 1936. And subsequently, several provincial legislatures, such as Delhi, Bombay, as I said, Bengal and UP, they passed their own Waqf legislations. But the first legislation post independence was a 1954 Act, though that was not operated across the country, but that was the first post independence.
So where was it operative, if not across the country?
On certain few states, like as I said, that UP developed its own, and they were operating.
So this 1954 law was a national law, or is one of the states passed it?
No, it was a national law. It was a national law, but states had that. They passed their own depending on the requirements that they had. So, and very interesting thing is that the Waqf tribunals got introduced for the first time in UP Muslim Waqf Act in 1960. So even prior to this, while the 1923 Act provided adjudication by commissioners, the 1954 legislation relied on civil courts. Whereas in 1960, this was being done by the tribunals, and we know that the Article 323 in the Constitution was by way of 42nd Amendment in 1977. So regarding tribunals, but here the tribunal was introduced way earlier. So thereafter, this post 1954, the major milestone came in 1995 Act, which was a very comprehensive legislation dealing with the administration of Waqf. And then the 2013 amendment, which was after very wide consultation, further formalized this system. But it is notable that if you see that in all these legislations, pre-independence or post-independence, only provided for administration of the Waqf, while at the same time recognizing and protecting the basic religious tenets around the system of Waqf. So, for example, the oral creation of Waqf and as its consequences, oral appointment of Mutawalli being a basic principle attached to Waqf was recognized in all legislations. Then, Waqf by user, judicial doctrine recognized even prior to any legislation was also recognized thereafter.
What does it mean? Waqf by user means?
Yeah, the Waqf by user is that assuming that when I dedicated it some 500 years ago and I had no provision of any thing which I can write or I can retain or something, so I dedicated it assuming for a graveyard. Now 500 years ago, thereafter the people kept on burying their deads in that graveyard. So by virtue of its use from time immemorial, it is waqf by user. So you have a dargah wherein you have a saint, you resting abode of a pious saint, or you have a mosque which you have constructed, or a graveyard that you have dedicated, and over hundreds of years it has been used in the same manner. So that becomes waqf by user. So all these things were being recognized by statute. So as I said in the beginning, that there are certain religious act. So if there is a religious act, it is over the centuries, over the years, it is there. The acts and statute, they recognize it and capture it as closely as possible in the statute. So now, if you have an example, if I give that there is a fire around that, and then the Hindu Marriage Act, you take seven when rounds of that fire, and then that the marriage is being recognized. Now, this is being captured in the Hindu Marriage Act. Similarly, the Waqf Act recognizes a religious activity. It does not creates it. So the definition that it tries to develop and capture is as close to the real act itself. Now, after you have captured it in your statute, you have only recognized a pre existing act, religious act over the period of time. So, if you have not created something, you have only recognized it and captured it in your statute. The point that I'm trying to make is that if you have done that, then you cannot alter, you cannot change that definition. The definition and that act was pre-existing. The legislation only captured it from 1913 to 2013.
So now, does this bill does it seek to change the character of what Waqf is by changing the definition? Is that what you're trying to point out?
Yes, the 2024 bill, however, seeks to reverse these remarkable legal developments and milestones which were being achieved over more than 100 years. Now, it is trying to interfere and alter and tweak the very definition itself.
How does this bill define Waqf? How is it different?
Yeah, if you look at the statement of object and reason even, it says that in view of the above, it has been felt necessary to amend the act with the aim to overcome the shortcomings and to enhance the efficiency of the administration and management of the work property. Now, before this, they say that they are the including the definition of the waqf itself. If you look at the statement of objects and reasons, it very clearly indicates that not only they are going to change these certain aspects so far as its administration and adjudication and recognition is concerned, it is also indicating that they are going to change the definition. So this is something which was unheard of, which was never happened, that the definition is to be altered. So that is
So does the bill only say that it's going to change the definition, or does it offer an alternative definition?
no, it what it does is that it surgically removes certain portion of the well accepted principles and foundations through judicial pronouncements and practice. So if you do that, then what will happen is that if you remove certain aspects in the definition clause, you have a very peculiar sort of a situation where you will be not equipped with certain things in the other parts of the act when you have altered the definition itself. That's a very serious thing.
Like, can you give a couple of examples of these principles which this act sort of alters or tampers with or whatever? Because I say from what you've said, I understand that the existing legal regime starting from 1913 till the present, there are two sides, two aspects which you really highlighted quite well. One is that it acknowledges the legal regime recognizes that this entire Waqf is a religious act by a person, by a Muslim. Number one. Number two, it having recognized this religious act which stems from Islam religion, it then provides a framework for administering the socio-economic effects of that religious act. That is all it does. Whereas this bill which is being introduced, it goes beyond looking at the socio-economic administration of this religious act to tamper with the religiosity related aspects of that act of dedicating Waqf itself. Is that what you're saying?
Yes, you see, it not only fundamentally removes the Waqf by user concept, then to dedicate it, it further gives a threshold that you need to be a Muslim of at least 5 years of practice. Then it goes on say that okay, you cannot appoint a mutawalli orally. So what actually you are doing is that assuming that I as a Muslim want to dedicate it, then there will be a test on me that I have to prove, and I don't know how they are going to do it. That you should be a practicing Muslim of 5 years. How will you determine that? Then another aspect of it is that the powers which were being given to the board, because the board is an expert body which recognizes and registers a waqf, the same authority is being taken away and is being given to the collectors. Then the adjudicating expert body is the tribunal. The tribunal's powers are diluted to the extent that the expert member is being removed. Then the tribunal's finality is being removed. Then after this, though so far as the administrative part and supervisory part to the boards is concerned, the character of it is completely been altered by making it a majority of non-Muslim members to come on the board. So all these things, the intent of the Waqif, who is the dedicator of that property, how he wants to utilize it, and the manner in which the entire superstructure for supervision, administration, and adjudication is concerned, it stands altered by way of this bill.
Right. So, does the bill offer any kind of reasoning behind, say, for instance, transferring the power of adjudication? Sorry. For instance, having a majority of non-Muslim members in the Central Waqf Council, or transferring this administrative, calls to district collector and so on. Is there any reasoning given for these changes?
See, there is no just actually the act as we had it in 2013 was after a very, because it requires a very deep knowledge of the religion. It's over the period of time, the judicial pronouncements, the difficulties which have been faced post independent. After factoring all those aspects, the 2013 act which we have right now is one of, and it was a fine legislation so far. So the first question that arose was what was the need and who asked for the amendment so far as 2013 Act was concerned. There is a silence on that. That if you look at the statement of reasons or object, it just uses the word it is being felt. Now, who felt it and why it felt it, it's not clear. Now, without any reason or without any discussion or without any consensus, these amendments were being formulated. Now, that's the first aspect. Then the second aspect is that in that, when you are going to make changes and interventions in the definition clause itself, that will have a very long term bearing. So definition clauses are being tweaked and worked by user. Now, in India, almost 60% of the properties like 8 lakh properties which are being indicated, that 8 lakh Waqf properties are more than half of them are Waqf by user. So, then after this, the manner in which the boards used to function, a board used to set up, the boards were being an elected body. Now, those elected bodies are now being made a nominated bodies.
Who will nominate?
The state government. So the state government now, the if you look at how the board is, that whatever the equilibrium that was being achieved over the period of time, it does not exist anymore.
So, is there any requirement that the nominees who would be sort of nominated, they have to be Muslim or they don't have to be?
Yeah, they the nomination, it says that at least two should be non-Muslims, but the condition for having the Muslims, if you read it in such a manner, is such that see, under the existing act there were 21 members in the CWC, which is the apex body, Central Waqf Council, consisted of 20 members. Now 20 Muslim members, the bill reduces to 10. So from 21 members, 20 used to be Muslims. Now only 10 could be Muslim.
So, is there any reason why reducing the numbers from 20 to 10 is not a good idea?
No, no, there is no reason as to why they are changing this.
No, but I mean, but say when objectively is 20 for any reason a better number, assuming all 10 are Muslims, would 10 be in any way less of a good idea compared to 20? Should there be 20 members? Is there a
No,
reason why there should be 20 members and not 10? Is what I'm asking.
oh, no, because the majority now in the Central Waqf Council and the State Waqf Board will be of not Muslim members. So the majority has shifted. Now, second aspect very interesting is that, see, here the in 2013 Act, it was very clear that any person can dedicate for work. So a non-Muslim can also dedicate his property. Now here you say that no, now only Muslims can dedicate property for work. But at the same time, you are reducing the Muslim majority and you are introducing the non-Muslim majority, whereas at the same time, you are taking away the power from the non-Muslim to dedicate for work. So that's a dichotomy. That there you are making the non-Muslims, they cannot do it, they cannot dedicate waqf. At the same time, you are increasing their majority. And of course, making a, now this is Article 25 and 26 is to be seen that secularism, which is in the preamble in Article 25 and 26, empowers the communities to manage their own affairs in their own way by them. So even if you look at the equality that has been prescribed in Article 14, and if you look at Article 16.5, wherein there is a public office and an appointment and reservation is there, even there, if there is any special, as a specific religion or a specific
These
board
are articles of the Constitution.
of the Constitution. So there is an exception. There is general equality which is there in Article 14. Then the exceptions to that also recognizes that the religion, particular religion, should be given place and manner in which it is supposed to be done under that religion. So what is now being done is that in a wrong and misinterpretation of equality and secularism in Article 25 and 26, this is being disguised in this manner.
Right. We will come back to this bill in a bit, Fuzel. But don't do you see? Would you say that there are no problems in the way Waqfs are administered today, as of now? The status quo, is it everything? Is everything fine, or are there certain ways in which they could be improved? Maybe this bill is not the way to do it. Is there something along those lines that one could observe?
Yeah, see, the problem, if any, with Waqf administration are not able to be cured by legislation or by taking away or bridging the very basic principles of the systems of Waqf. So, if individuals occupying positions do not function properly, the law cannot ensure their actions to be honest in that manner. So something you need to do about those mechanisms, but you cannot change and take away the very fundamental tenets of that particular act, that is Waqf. So even with all the amendment the bill proposes, you can
There
give
is
a
one amendment which says that every all the works have to be registered on a digital platform within 6 months. And yeah. So how will that affect? I mean, you're talking about work by users, which has been going on for 500 years now. All of them have to be registered online within 6 months. Is that likely to happen?
it's an onerous condition. There's a condition which is unseen so far, unheard. You see, very recently in UP, state government has asked all its employees to disclose their movable and immovable property. Employees, present employees, to disclose their movable and immovable properties, and they are not able to get it done over I think more than 6 months or something, and still they are. So to ask for these properties which are not individually been, who is the owner? Not the Waqif is the owner, neither the Mutawalli is the owner, not the Waqf board is the owner, not the government is the owner of these properties. These properties are being owned by the God Almighty. The community and the mechanisms that it has, they look after it. So where these properties are not being privately owned and privately managed, how do you expect that they will be so diligent and they will be so competent and forthcoming to be able to comply with these conditions?
So since they are not privately owned, Fazil, I'm just curious, like what happens when, say, the government uses its eminent domain powers to do some land acquisition, and one part of the area is a Waqf property. How does it go about that? What happens then?
The eminent domain, of course, the government can, for public purposes, can acquire. There is no quarrel about that. That they can acquire wherever there is a need. But the question is that if it is not being acquired for those public purpose, and the community at large is able to do it or is doing it, what is the need to interfere in therein? And that too without any deliberation, discussions, and creating consensus. In absence of that, the 2013 act was after the Sachar committee. There were so many recommendations of the Sachar committee which are being incorporated, and that's a very well reasoned and well functioning legislation. It asked that the section 4 of it sought for a survey, that there should be a survey of all the work properties in the country. Within 1 year, a survey commissioner be appointed, and that was not being done for 10 years. So if you don't do certain things which the act wanted it to be done, and then you say and turn around and say that no, this is not proper, this is not functioning, it needs to be made efficient, and it needs to be changed. So that's something that once at one hand you don't do it, and the other hand you say that okay, it's not happening, so therefore we are doing it.
Coming to some of the specifics, Fuzail, I mean, and you also spoke of interference. Now, here's an interference, okay? Now, the bill proposes, that there has to be a certain kind of auditing of works, how financial auditing. So, is there any auditing which happens as of today, and what is the kind of auditing which the government wants? It says, I think, if it feels that some works have to be audited, it will then say that, this kind of auditing has to be done. How does that work? What is the status now, and what does the bill want?
See, the auditing requirement with Waqf are nothing new. Even in the 1923 Act, the Mutawallis had to audit their account and furnish information to the jurisdictional courts. So, in the existing 1995 Act, again, the Mutawallis were required to maintain accounts and submit it to the board under Section 46. Now, under 47, the Awqaf with net annual income of more than 50,000 rupees, the account shall be audited annually by an auditor appointed by the board from a panel of auditors made by the state government. For Awqaf, which is Waqf with net income of less than 50,000, however, it was not necessary to choose an auditor from the state panel, and while in such Awqaf, the submissions of accounts was sufficient. So accounts of 2% of such can be audited annually. The bill firstly changes this requirement of annual audit by raising the net annual income to 1 lakh, by reducing the net annual income from 1 lakh to 50,000. So, sorry, from 50,000 to 1 lakh. So, earlier it used to be at a lower level. A work for 50,000 income to had to get it audited. Now, the 50,000 thing is gone. Now, somebody who is above one and above only has to get that Waqf audit or Waqf audited. Then it introduces as the auditor appointed by for this purpose of auditing. Even 2% accounts of Waqf having net income, which I just said, of less than 1 lakh would also be from a panel prepared by the state government, and the state will fix this. So that will have a bearing so far as the financial health of that Waqf is concerned. The state governments had the power under the intimation to the board to cause audit of accounts of any. It can order State government can audit any Waqf in the entire state. Now the bill seeks to include a similar power to the central government as well. So the key terminology of under intimation to the board is missing. So from this addition signifying that audits by central government would be used in a unilateral manner in addition to the already the authorities that we have seen. So it also introduces clause 2 in section 47 that requiring publication of those audit reports. A whole novel and unnecessary provision will definitely impinge on the, I think, independence of these Waqf. The existing act requires that the cost of audit will be borne by the Waqf, provided it does not exceed 1.5% of the annual income of the Waqf. The bill seeks to remove this provision. Again, while the boards have the power under 48 to examine the auditor's report and call for the explanation and pass orders for recovery of the amount certified by the auditor, the bill seeks to provide for publication of these orders. So while largely the auditing requirements remain the same, the publication requirement is certainly, I think, with some mischief to deter people from donating to Awqaf.
So, are there any other religious institutions or equivalent bodies which are who are the bodies required to publish their auditing reports?
We seriously think that there is nothing as such in the private domain. So that could be, of course, for the government institution which are being run by public funds, but not for the private institutions.
Right. So this sort of seems to indicate, Fuzel, and many people have also pointed out that the bill, and if you look at the general movement of the various provisions we've been talking about till now, there seems to be a move towards centralizing power with the union bureaucracy, such as the collectors and revenue departments, and sort of taking power away from the actual work boards themselves. So, is there any merit in thinking that there is a centralizing tendency in this entire bill, which is that something that is a valid way of looking at it?
Yes, see, a very important aspect that is this, that once you recognize that this is an act, the Waqf is an action in religion, in the Islamic faith. Now you have to take care of the nuances around it. As I said, that this is a charity wherein somebody wants to please God Almighty, and he wants to dedicate it to God Almighty in order to please Him in perpetuity, and therefore the fundamentals of that religious act needs to be kept in mind. Now, around that, whatever the manner to survey, recognize these properties, to prevent them from maladministration and being sold off, then if there is any dispute, then the recognition and adjudication that has to be done with that sensitivity in place, that this is a particular religious activity, and the protection which is being accorded under our secular constitution is very clear in article 25 and 26. What actually now is being done is that we are shifting this whole recognition and administration in the hands of the collector, who is, as we all know, there's nothing on this, but then they can't be a judge in their own in their own cause, because the collectors are most of the time, of course, they are the representative of the state. They will be recognizing, adjudicating, and they will be sending the report to the board. So instead of the specialized body, it is a general authority who is a collector who is being now entrusted with this authority. Then the CWC and the board, how they are being constituted is of now becomes from elections to nominations. So again, it shifts the power to the hands of the state government and central government. So power shifts from the boards to the collectors. The board themselves are being constituted by way of nomination. Then the super supervisory authority, CWC, is again being nominated, and wherein now you have earlier the that requirement of Muslim members has been reduced to this extent that this becomes the majority non-Muslim body. So all that shifts. Now there is in the tribunal there was a member with Muslim knowledge is removed from the tribunal. So all those safeguards, specialized, and forget the safeguards, even the specialized knowledge of the subject.
Right. Fuzel, let me just, sorry to interrupt. Now, is there, I mean, apart from what you said about, knowledge and sensitivity to Islamic law and, religious aspects and so on, is there any ground, purely say constitutionally speaking, you can, maybe is there is there is an equivalent legal regime for other religions, Hindus or Christians or whatever. Is there any constitutional ground on which one could say, okay, mandating non-Muslims in Waqf boards is not acceptable in a religious administering body, a religious act administering body? Is that a valid argument? Can one say you cannot impose or mandate non-Muslims in a Waqf board? Is there a ground to make that argument?
Yes, yes. See, there is a right to freedom of religion, right? Article 25 says there's a freedom of conscience and free profession, practice, and propagation of religion, subject to only three conditions: that there should be public order, morality, and health. If public order, morality, and health is not being disturbed, you are supposed to have your own system to set up, administer, and propagate. So it is a clear violation of Article 25 and Article 14. Now similar provisions exist for the Sikh community, for the Jain community, for various communities of Hindu religion. There are similar legislations which are
Such
there,
as, such as.
such as we have the Jain. In Bihar, we have two legislations of Jains. Then in South India, there are a series of legislations which are there. I think there are as many as 12 legislations, especially for various religion and various religious denominations which are in operation in the country, and they are being governed according to. Even we have the Kashi Vishwanath Act, which is there for the Kashi Vishwanath shrine in Varanasi. So, can a non-Hindu be a CEO of a Kashi Vishwanath temple? No, that would not be the purpose of secularism. That will be not the purpose of Article 14. The Article 14, 25, and 26 protects religion, various denominations, sects, subsects, and gives them and empowers them. So intermixing of that by saying that no, it is secularism and equality is misreading secularism and equality, in fact.
Right. Thank you so much for sort of explaining this very complex terrain. Fuzel, one last question, before we wrap up. We're running out of time, unfortunately. Now, there was a JPC meeting on this Waqf law where, they were. I mean, the agenda was to sort of look at the draft bill and look at all the public suggestions, but then it probably didn't go well. The opposition leaders walked out. They've written a letter to the speaker saying rules were not followed. I mean, like, what's happening? You also, I think, did make a presentation before, where he was were invited to present a depose before the JPC. Can you talk a little bit about that aspect as well?
Yes, since it's a privileged communication and is a confidential, so I can only say this. Yes, I appeared, and it was is a very good session. It went on for more than 2 hours or something, and there was a very freewheeling discussion on various aspects, and there are people who are going. But what now appears is that, see, that is all the purpose of JPC is is a mini parliament wherein it represents the parliament in a small form, but it is the entire composition is there. So it is interacting with the citizens to know their views on this. And primarily with the stakeholders. Now, I think perhaps the difficulty now is arising when the non-stakeholders and organizations with a clear Muslim agenda or views, they are being invited. So something like this, it's a little perhaps it might be disturbing in the public domain, that okay, those who have a certain knowledge, attachment or involvement into the subject need to be invited in order to get a clear picture, rather than people who are simpliciter, or the whole their qualification is in opposing certain things. So that aspect perhaps could be a reason why this has been reported in this manner in media, and there's a walkout or whatever. But nevertheless, that JPC, I think, is very important, is a very important forum, and very critical function is there. It should go deep and far on this subject, and should have more interaction with, so in order to understand it, because there's an eyes and ears of the parliament, and that it will record and report everything to the parliament. So I hope it goes on, and it goes and interacts with more and more people across the country, and it doesn't rush up the whole process.
Right. I mean, it's very fortunate that you were invited to depose before the committee. But until the draft was made, were Muslim stakeholders involved in the drafting of the bill, to your knowledge?
No, that's a if you look at the statement of reasons and objects, it's just felt. That's what I'm saying. It just felt that it says that it felt that okay, there is a need for that.
So the Muslim stakeholders, nobody from the Muslim community felt. It's just a random felt. Is that what you're saying?
Yes, the statement of reasons and objects very clearly indicates on not more than but on two occasions. And it refers to consultations which were being done prior to the 2013 Act. It does not indicate any consultation from 2013 till 2024. So the previous consultations which are stale, or which are already culminated into the 2013 draft in the act, that they are already there in view of the Sachar committee and other things. What is the novel thing that has now come up, which called for such a drastic bill? That is something which is still a puzzle for every one of us, that how and why it has come up in this manner, on who's asking.
Right. Who wants this bill? That's a good question to ask. Thank you so much, Fuzail. We've run out of time. It was an absolute pleasure talking to you, listening to explain the various provisions, the implications of the various provisions, and the historical background in the run up to the current juncture. Thank you so much once again.
Thank you. Thanks a lot for inviting me. Thanks a lot.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.